Good morning. I want to thank Martin, Kenny & Co. and Astigarraga Davis for the cocktail reception last night. So we're going to have three concurrent sessions for the entirety of today until the final session of the conference on the Panama Papers. The session that's going to take place in here right now is the IRS Whistleblower Program 10 years on, what works, what doesn't, and what must change. The session to your right, my left, in that room, is advanced techniques in asset investigation and debt enforcement, and then upstairs in the Lincoln and Lummis room, we have solving previously unsolvable cases with digital forensics. So this is the IRS Whistleblower Program. It's being moderated by Dan Reeves, who's spoken at several of our events. Dan used to head the IRS's Offshore Programs and Initiatives unit. He was instrumental in developing the techniques to help the IRS investigate offshore tax evasion by US taxpayers that sort of initially involved the credit card program and developing everything from there, and the big investigations into UBS and other offshore banks. He's now retired and in private practice, and Dan will introduce the other panelists.
All right, thank you, David. Good morning. As David said, my name is Daniel Reeves. I'm the former senior advisor on offshore matters in IRS's Offshore Compliance Initiative. I retired from the IRS in 2012 and currently work as a private consultant to law firms and to financial institutions on offshore tax compliance issues, anti-money laundering issues, and also IRS whistleblower claims. 2016 marks the 10-year anniversary of the IRS Whistleblower Program. The program pays out cash awards to those who come forward with original source information that leads to the collection of more than $2 million in tax, interest, and penalties. It has grown and evolved since it was founded. It has gone through some early birthing pains and has made great strides, I think, in terms of where it is today. With me today to talk about the IRS Whistleblower Program are three nationally recognized experts in the field. First of all, to my immediate left is Lee Martin. Lee is the National Director of the IRS Whistleblower Program in Washington, D.C., where he oversees all aspects of the Whistleblower Program and serves as the principal advisor to the Commissioner of the IRS and other top officials on the execution of the program itself. Lee previously served as Deputy Director of the Office of Professional Responsibility, where he oversaw the conduct of attorneys, CPAs, enrolled agents, and other professionals who practice before the IRS. Next to him is Dean Zerby. Dean is a founding partner in the law firm of Zerby, Fingeret, Frank, and Jadoff, a Texas firm, but he works out of Washington, D.C. From 2001 to 2008, Dean served as the senior counsel to U.S. Senator Charles Grassley, chairman of the Senate Finance Committee, where he quite literally wrote the whistleblower law that established the IRS Whistleblower Office in 2006 and created the monetary award program for tax whistleblowers. Dean specializes in representing whistleblowers with complex submissions and has represented a number of tax whistleblowers in filing successful claims, including the most famous of all, Bradley Birkenfeld, who is the most successful whistleblower in U.S. history. Next to him is Brian Skarlatos. Brian is a partner in the law firm of Kostelanetz and Fink based in New York City, where he specializes in representing clients in sensitive matters, many involving negotiations with government agencies. Brian handles all types of civil and criminal tax controversies, including white-collar criminal and regulatory investigations, complex litigation, tax whistleblower claims, and voluntary disclosures. Before I turn the microphone over to them, I do have one caveat that I need to give you. which is that Lee is here in an official capacity to talk about the IRS Whistleblower Program. He has not been authorized to engage in any kind of general debate or discussion about the pros and cons of IRS policy towards offshore financial centers or U.S. policies in general. What he is going to do is talk to you about the evolution of the program, how it started, the progress it's been making, and where it stands today. So with that, Lee, I'll turn the podium or the microphone over to you, whichever you prefer.
I'll try it. Try it here from my notes from that standpoint. So can everyone hear me okay? All right. Well, good morning, everyone. So I appreciate the opportunity to come and speak to you all about the Whistleblower Program. When I was asked to do this, it was kind of interesting because I've only been in the position since August, but it seems like I've been running a marathon ever since I started. And we'll talk about some of the things that we're doing in the program and some of the factors that I face, because I think it's very apropos that we look at it today on what has been working under the program, what doesn't work. And there again, when I say what doesn't work, it's hard necessarily for me to criticize myself. So I'm sure my other panelists will do that for me. And then from there, what needs to change. And that's a plethora of items from that standpoint, but that change alone can't be done by the Whistleblower Program. What doesn't work, again, can't be solved by the Whistleblower Program. But I think there are some great things that I'll talk that you personally or you professionally, where the Whistleblower Program matters from that standpoint. So I'm going to apologize up front because some of the items I'm going to discuss will be historical. And so from that standpoint, you probably already know the information and it'll probably be boring. The rest of it will probably be new to some of you, and again, it may still be boring. So I'll apologize on that up front. So let's take a minute and talk a little bit about the program itself. And so for those of you who don't know, the program was established in 2006 under the Tax Relief and Healthcare Act. And the law applies to files that are enacted, or claims that are enacted after that, December 20, 2006. And the law basically changed the program from a may pay to a shall pay. So under the may pay, the program is what we classify as a 7623A, and under the shall pay is under 7623B. So what do we do under the Whistleblower Program? And it's very simplistic in that sense. The office analyzes the information from individuals described in 7623B, and we coordinate with other IRS units to investigate the matter and make award determinations and make award payments. And as I said, and what's key here is that under the statute, the whistleblower office has the ability to investigate the matter itself or sign the matter to be investigated. It is more efficient because I don't have in the group a large level of expertise across the board in the sense to better utilize the expertise that exists within the IRS. So that's why we assign the investigation matter to the groups that does the investigation. So we do a lot of coordination with TEGE, with the SBSE group and the LBNI group, and we do it with CI. So there is a large coordination part of my role and my job that I deal with for them. They will do the investigation. They will then, in turn, after they've completed that, they will then fill out a form and send it to my office, and that's where we take back over. So that part of the investigation, I just want to make sure everyone understood that I don't do that as a group. I have that done by other parts of the IRS. Once that is completed, I take the form and I do my work again. I look at the form and I weigh the merits of the information. That's what I'm there for. I apply positive and negative factors. There are 8 positive factors. There are 8 negative factors that I use to make a determination whether we make an award. And then from there, then we will do the award payout. Okay. So let me talk to you about what I believe is working. And then jointly, we'll really talk a little bit more about what doesn't work, and then we'll finish up with some of the things that talked about needs to change. So first, FY15, that was a big year for the awards program under the Whistleblower Office. We made 99 awards, and we paid out $103 million to whistleblowers. That total award amounts represents 20.6% of the amounts we collected. We collected, or had collected proceeds in that year of 2015 of $501 million. That is significant. Now, let's talk about the program itself. Since 2007, since its inception, the Whistleblower Office, under the B program, the Whistleblower Office has paid awards in the amount of $403 million based on collected proceeds of greater than $3 billion. So I would hope that you, just like me, would agree that it is without question that the Whistleblower Program makes an important contribution to the tax system by helping encourage tax compliance and by contributing to the tax gap reduction. Let's talk about a couple other things I believe is working in the program. In February 2015, my office had only one person handling most of the offshore claims. We now have 4 analysts due to the growth in number of claims that are associated with it. At the end of FY15, my total staff amounted to 61 individuals. That's grown from 2 people who started out in 2007. I now have 61 total with 19 senior analysts associated with my program. The bulk of my group works out of Ogden, Utah. For those of you who have made whistleblower claims, that's where your initial claim goes, to the group there for processing. We recently made a number of changes in regards to the annual report. 7623 requires that on an annual basis, my office has to report out on the results, report out on 7623 program, as well as the results of that program. For those of you who follow the annual reports, a couple of things have changed if you reviewed the latest one. We made significant changes to the way the report was presented. We presented new facts and data and graphs on the charts, so more, how can I say, visual presentation of the data. And one key item too, we made a significant improvement on when the report came out. If you recall, the FY14 report came out in July of 2015, so the 2015 report came out in February of this year. A couple other areas where I thought are significant. Those of you who may have followed the GAO report, GAO recently put out an audit results in October of 2015. One of the key items that they discussed was the backlog that was happening with the Whistleblower Office. Again, a very negative item. At that point, when I took over the organization, I think there was identified of almost a 5,700 claim backlog. I'm here today to tell you that the backlog itself has been addressed, and a lot of the areas that they discussed, the backlog has totally been eliminated. One other item of importance too, when you send a claim, it may have taken before a while for us to acknowledge that claim, but I would hope that you would acknowledge now that it is happening within generally about 30 days, if not sooner. So, let's get on to the negatives. By statute, 7623 grants me the authority to pay awards for information necessary to detect underpayment of taxes or violation of the Internal Revenue laws. I'm going to say that one more time. Detection of underpayment of taxes or violation of Internal Revenue laws. Now, why did I repeat that? The IRS gets thousands of claims each year. In FY15, I closed 10,615 claims, out of which 53% of the claims were rejected because the allegations were either not specific, not credible, or very speculative in nature. Okay? So even though there is a large volume, guess what? It doesn't mean that that's a good referral. I closed another 11% of the claims. They were denied because the information was already known, or lack of resources within the IRS, or it was surveyed. Also, there were also another 10% that was closed because they were below the threshold for IRS action. So just because a neighbor buys a new boat doesn't mean that you need to make a whistleblower referral. Okay? So if you add it all up, that's almost 75% of what was closed in 2015. So a couple other things in regards to what's not working. I hear this all the time, and I want to be very specific in what I say to you. What's happening to my claim is what I'm asked, and why does it take so long to pay an award? That's the two biggest complaints I generally get. So let's talk about what's happening to my claim. Communications with whistleblower by my office happens at maybe a couple possible points that let's discuss. The first point is the acknowledgement of the 211 form that you send into my office. The second point may be if there is a debrief that is conducted. That is the second point that you may see. The third point is when we begin administrative proceedings. And administrative proceedings generally happens after we have full collected proceeds. Now, there is a significant gap between when what is considered the time at debrief and the time when we have full collected proceeds. That can be several years. So when did I say? At the acknowledgement and at full collected proceeds. The collection statute itself runs for almost 10 years. Okay? The RSET date, that's the refund statute. The RSET runs 2 years. Okay? We have to collect proceeds. So it's a significant amount of time for all of those things to happen. Okay? Why does it take so long to pay? The IRS, again, pays awards from collected proceeds, and as such, no payment is made until the taxpayer has exhausted all of their appeal rights and the statutory period for filing a claim for refund has expired or either been waived. All of those are prerequisites to the payout to a whistleblower award and can add several years. It takes on average between 5 to 7 to 8 years to pay a claim, and we have some older than that. So, let's get now back to the positive. So what needs to change? Number one, as I said before, 10,600 rejected. So what am I going to start with that needs to change? We need better referrals, first of all. It takes quite a number of resources to cull through all of the referrals to find those that are actionable claims. The referrals need to be, and I will reiterate this point, more specific, more credible, and less speculative in nature. Now, the claims themselves, there has been some help with that. As more attorneys are getting involved with that, they have helped to screen some of the claims coming. However, again, it is still up to the whistleblower whether they file, so it may or may not stop the claims from coming in. My office is also developing guidance to help to say what is a great claim. Hopefully this guidance will provide better communication and help with the claim process to explain it. What else needs to change? Well, let's talk about the number 2 item, perception. Everyone in here has a perception. And I've learned something that has grown up, that perception may be right or wrong, but it is what it is. Okay? Let me deal with one particular perception. We're not just sitting on your claims and just throwing them back, making paper airplanes out of them. Okay? We're not doing that. We do work claims. As identified before, we did have a backlog. That backlog, which probably had some impact on the timing of it, has been done. We're moving things through. And as I'm here, they did not put me here to fail. Okay? They brought me here for a reason, and that's to move claims and to process claims and to pay awards. That's what the whole program is about. We want more awards. We want to pay out bigger claims. We want to do that. Okay? We have a large tax gap, and this helps with that reduction. So it behooves all of us for me to do that and the program to be successful. Timely communications. I hope by now you've seen that there are only certain points that I can interface with you, the whistleblowers. Let's go over it again. At the acknowledgement, at a debriefing, if possible, and then at the start of administrative proceedings. And administrative proceedings, which I didn't talk about before, can take several months to complete, depending on what happens within it. However, I'm doing everything in my power now to start admin proceedings at the earliest possible time. So look for some things to come out in regards to that, for how we move that far. So again, I will do everything in my power to move this through as fast as possible. In addition, in 2015, the IRS started a program review of the Whistleblower Office to identify opportunities, what we call to maximize the efficiency and the effectiveness of the claim process. We started a Lean Six Sigma effort, whereas we looked at the initial claim processing, we looked at how the claims are reviewed under the classification, we're looking at the award process itself, and I'm looking at the technology we use in-house. That's the end point. I'm also putting together all of those recommendations, and then we will move as soon as possible to implement possible reforms in those areas. I've also got a recent 10 recommendations from the GAO audit that I am working towards. Obviously, good recommendations, and we'll be working forward to put out some answers on those as soon as possible as well. I am also wrapping up a TIGTA audit at this point, where we're reviewing the statement of facts. So as you can see, I have plenty of help in making sure that I am as efficient and as effective as possible. So lastly, just a couple of more things. So we are seeking help from Congress to enact 2 legislative proposals in the administration's FY16 budget, which would provide better protections for both the whistleblowers and the taxpayers. Specifically, the first proposal would provide legal protections to whistleblowers from retaliation by employers, much like those protections accorded under other whistleblower programs. As you know, people are putting their careers at risk by coming forward. And I want to make this program more effective, and I believe that if we had those, we will have more awards, specifically addressing more violations. The second item that I'm looking for is a legislative proposal that would provide stronger protections for the taxpayers by imposing sanctions on whistleblowers who improperly disclose taxpayer information obtained from the IRS in connection with the whistleblower claims. Right now, whistleblowers receive signed confidentiality agreements to review information under administrative proceedings. However, I cannot do anything to them at the end of the claim after payout if they reveal information or it's found out that they've revealed some information. The only thing that I can do is before, if I found out that before payment is made, I can reduce the amount of the award. That is the one thing that I can do. Outside of that, I can't do anything else. So, I've talked to you about what I believe works. I've talked to you about what I've heard that doesn't work, and then some of the changes that I believe are needed. If we do that, guys, it'll make the program better. Will it make it perfect? Not necessarily, but let's strive for one improvement at a time. So, thanks.
Go ahead. Here, take this.
I want to let you, because I think you may want to chime in on some things, and then yeah. So I want to, I think, follow the good framework that we've had here for the presentation, and again, kind of talk about what works, what doesn't work, and kind of the road ahead. I think on what works, let me start off with a strong compliment to Lee and Commissioner Koskinen. I think they've really put a lot of coal in to get behind the program in terms of getting the staffing. And you're exactly right, Lee. We were both talking last night that it used to be that you wouldn't get kind of receipt of a claim or acknowledgement of a claim and a claim number for months when you would file, and that was the devil, because we would have our clients calling us every day saying, is it lost, is the dog eating it, are they making paper airplanes out of it? And so that really has been hugely improved. I'd say, we usually get them right within 30 days, and that sounds, technical or paperwork for maybe folks out there, but I would say in practice, it's been very helpful in terms of that. I would say what works as well too, and I'm being kind of very practical here, and we can talk about big picture as well too. I agree with you. I think the program overall is working, but there's tremendous opportunities for it to do anymore, and to do even more. And I would say for folks from foreign nations that are here, the U.S. is really the only country that has got a whistleblower reward program that is a shell pay. Germany's got a pretty good program that puts out a lot of schnitzel and beer for people if they want to come forward, which I think is pretty good. But basically, that's about it. But I would say if you're serious about going after offshore illegal accounts, you've got to have whistleblowers be part of that. You can kind of put in this reporting requirement, that kind of reporting requirement, but it all hopes on, boy, we're all going to do the right thing. Whistleblowers, and not just in this field, but across the field. This law was based on the False Claims Act of the U.S. government, which has brought in billions and billions of dollars over the years, and kind of to your point, Lee, shows how much you can really potentially raise in this. It really showcases that bringing in whistleblowers is a critical part of going after fraud, going after shenanigans of that nature. So I just say that as a general point for those on the international scene that are looking at what you want to do here. You've got to make whistleblowers be a key part of it. I know France is looking at it now, and that's fine. I want to talk about going back to what kind of works more on the tactical or granular level. I think submissions that Brian and I were talking about this earlier, that I think early on we were a little bit skittish about going into criminal or going into criminal shops at the IRS for kind of some technical reasons. But actually they, I think, are extremely good, because they're used to working with informants, and they've been very receptive. I've had a number of cases that have paid out, and they're terrific at acknowledging the whistleblowers' work.
That's the beauty of it. I used to actually shy away from criminal cases because you have to go through the whole criminal process before you get to the civil process when people actually pay money that you can get an award on. And so I'd say to a client who had a great criminal case that they wanted to blow the whistle on, I'd say, that's not as good as just going directly to civil. But now I've sort of changed my tune on that because, for what Dean said, CI is used to informants, they recognize the value of informants, and they actually get behind and promote the quality of the information. And you have an advocate within the IRS to talk to the whistleblower office and say, hey, this guy really did help us. He provided a great job, which you don't really get so much from the civil side of the IRS.
Right, and that's kind of on there. The one shop within civil, though, that I think is terrific and really has its bells on regarding whistleblowers is the Offshore shop at LBNI, and basically Dan, your old shop. I mean, I think it really comes from you and John McDougall's work and history in that area, that I think they really get it as well too, and are very strong in that area. And so I think that works. I think, again, the program overall works well in terms of getting, as you well said it, Lee, with numbers, getting good information, getting kind of bang for the buck in terms of it. One thing I'd say too, it's hard for Lee to kind of say this, but I would say, having had a number of clients getting paid out awards over the past few years, the whistleblower office is very fair with the award percentages. I mean, you can get an award percentage between 15 to 30%, and that's where advocates like Brian and I come in to say, you bet everyone should get 30% and every child's above average. But the reality is, as they mentioned, there are 8 positive factors, there's 8 negative factors. Sure, I mean, I'm gonna always tell you, you bet they should get X, but I would say that the whistleblower office is very square. When I look at it, I'm like, okay, that made sense. It's not like, are you kidding me? This person got this. I don't know, Brian, if you've got it.
No, sure. Once the whistleblower office gets the information from the field that they've collected proceeds because of the whistleblower's information, I think everything works pretty well when that comes.
Yeah. And then one other thing, I'll get more into the details on it, but on tax court is one of the key points of the law was not only that you're right, it would be a shell pay, but that you would have someone kind of there to make doubly certain that the whistleblower would get treated fairly, and that gives the whistleblower the right to go to tax court. You can go to tax court anonymously, and the tax court, I think, has been very pro-whistleblower, has recognized its role of being a protector of the whistleblower. And we'll talk more about tax court, but I think that's been a good piece of it that's worked. And then lastly, kind of on the what works, I think too what's forgotten is it does give the IRS a much better targeting of limited IRS resources. In other words, your success rate on cases that are brought with whistleblower information is much higher than the normal diff scores, things like that. And the truth is, it saves, of course, honest taxpayers. You don't have to put up with the grind from the IRS, you know, that they're focused more on the bad actors. So I think a lot of the things are working, and I think a lot of things are improving coming out going forward. So I think it's positive. Look at it. These programs always take years. The False Claims Act, which I mentioned earlier, which is hugely successful, it took years for that program to get up and running and to the speed where it is and get it improved, and that's just kind of the reality of it. When I think of what doesn't work, I think there's still a cultural issue, particularly in LB&I, and we were talking about this too, Brian. Do you want to go ahead and?
Well, yeah, sure. This is one of the big, actually, you just touched on what I was going to say. One of the biggest things that isn't working with the whistleblower program, and I'll preface this by saying, if you don't mind for a moment, Dean,
yeah.
It's important to understand what Lee's office does and what it doesn't do. And I think you touched on this, Lee, when you said, you know, we're administering and we're in compliance. They're bringing in the claims. They're making sure they're processable. They're determining whether they're A or B claims, reviewing them, and then if looks like there's something there, then they send them out to the field to be worked. Lee's office does not evaluate, doesn't work the claims and collect the tax. They send them out to the field. Now, I think the whistleblower program and the whistleblower office and what Lee is doing is an excellent job, and there's a lot to be hopeful for. What I still think needs work is getting the field agents who are doing the revenue agents, doing the audits, getting those people behind the program. I still do get the sense when I'm dealing with the field that a lot of them are, listen, you know, bless them, a lot of agents are overworked and underpaid. You know, all they do is get more inventory, and then they're told you got to take sequestration days, you're not going to get paid next week. You know, so it's not a great situation to suddenly come and say, oh, guess what, I got a new file for you. And if you work this file, that guy's going to make $10 million. I mean, there is I don't think, also a lot of the agents in the field, you know, they're very expert, and there's a sense like, we got it. We know what we're doing here. We're on top of this. We don't need the help of a whistleblower. So I think that's a cultural thing that once we can sort of, over time, get the IRS to recognize that this is a really strong leg of enforcement that you can use and maximize and prioritize some of this whistleblower information. You can't put it in front of everything else because then you denigrate other goals of enforcement and collection. But to recognize that this is really valuable stuff and give it the time and effort. And Lee, that's not your office, that's the people in the field. But once you change that culturally, that's when this program will take off.
Yeah, and I think Brian and I are talking about is in certain cases, the IRS can be very red hot on. Offshore is a good example, but I mean, we can be frustrated. We'll bring in a case, and just so you get a sense, and we'll talk a little bit, you know, Lee, you touched on it, but I'll kind of give it a little bit more vinegar about what I think a good case looks like. But again, Brian and I were talking that, you know, you could have a case that, say, it's a Fortune 50 company with a very senior insider, a very knowledgeable tax person laying it all out, and you would think they'd be on the bunny trail like that tomorrow. And, you know, sometimes they are, but I would tell you it's different than criminal, it's different than offshore, where it's, well, you know.
No, I mean, those are really the only kind of cases I want, because you're going to talk about what makes a good case. I want the insider who's got the PowerPoint that says, we're really committing tax evasion now, and, you know, they're flashing through, here's how we're going to do it. You know, and we have some of those cases, and you put it together in a nice package, you know, with the 20-page submission, with 200 pages of tabbed exhibits, it's all perfect. And I get the feeling that sometimes, you know, some people on the teams get very excited, and others, it's a big yawn, you know, it's like, oh, you know, we're already finished that audit cycle. We already have our inventory for the next audit cycle. You know, we'll consider it maybe. And it's like, come on, guys, this guy got fired because he raised this issue.
Right. And I think that's something, you know, Lee, I understand how your office has, you know, kind of changed with times, and even I don't believe everything that Congress puts out is perfect. I know that's a shock, close to perfect, but it's always worked. But when you look at the underlying statute, it actually did give your office authority to investigate. I know it's not, and I understand the reasons for that. But one thing I would wish would happen, and I think there was a bit of that, and maybe it's still going on, is that your office would have the ability to kind of ring the big bell to say, hold on, Tiger, what's going on here? Why is this case not being worked? And it's really almost taking it to the deputy commissioner level commissioner, because it was meant to be, an agent change or change, to kind of get people out of their comfort level. Because you're right, Brian, people get into, well, here's our audit plan, here's what we're going to do. We don't really want to change it for the fact that there's $300 million.
It's tough changing an audit plan. Once the audit plan's in place, it's tough to get a new issue in there. And, that's something that maybe LB and I will come to understand, that there should be a placeholder for whistleblower information in the audit plan.
Yeah, I think, this is kind of an old favorite one, but I'm ever hopeful. We've talked about, in terms of kind of things that aren't working, but I'm hopeful on, would be contracts with the whistleblower. When we drafted the legislation, we were told this was how the IRS wanted to handle kind of communications, and we, again, with the False Claims Act as a model, very much wanted to see more of a, and it isn't proper, appropriate, or needed for a lot of cases, but where it does make sense, that you actually would work with the whistleblower, with their attorneys, the folks who really know it. Because right now it's more of a one-bite apple kind of a connotation, but the reality is, for a lot of this, you need, and can benefit, the IRS can benefit with the limited resources mightily by having someone there saying, well, yeah, I'll tell you why they did that, or yes, I know what that memo means. Because one of the challenges of providing a submission is you're dealing with, again, Brian, you're talking about, you've got to say a corporate officer who's been there for 9 years doing tax, to try to unload all that knowledge and background in a limited resource is just very difficult.
It is difficult, and that meeting with that person can be invaluable. But it's tricky, because the IRS doesn't want to give confidential information that they shouldn't be doing, and so this contract that allows them to provide confidential information would be very helpful.
And I know you're working on that, Lee, and I know there's constantly a push. I think it's getting it down to the lower ranks to make them better understand that the door's open for that. Because when I talk to them, they're really, could we do that? It's still a feeling of, that's like going to Valhalla or going to God on high to get that approval and everything. And then I think one thing I would say is, I was very heartened, Lee, kind of, you elliptically said, well, we're trying to do some changes on the administrative side to improve communications. I think that's fantastic, and hats off to you. I think that's very, very commendable, and we're very excited to see how that fleshes out. The Hill, just in the Senate Finance Committee just a few weeks ago, Senator Grassley got into amendments. One was the administration's proposal on protection of whistleblowers. And I would say, Brian, I don't know what your experience has been. By and large, unlike False Claims Act, where the whistleblower has to be named, here it's anonymous. And again, that's a good example of something that works very well. The service, you have to give your name to the service, but the service is very good at protecting whistleblowers' information. Yeah.
And I've been on both sides when I'm representing a taxpayer against whom the whistle's been blown. So I'm defending the taxpayer. And the IRS is just very good at not disclosing that there is a whistleblower.
Right, at
we
all.
may suspect it, but they're not going to tell us that.
And even the information that you're provided, if they're like, well, because you'll get the killer email, from Jimmy to Jane says, hey, this is illegal, and you're like, this is great. But, they're very good at saying, well, if you do that, guess what? They're going to probably know who gave you that email.
Right. They're not going to take that email and give it to the taxpayer's representative. They'll work around it without disclosing.
So I think they're very, very good at that and getting the information out there. But so I don't, I'd be the last to say we don't need more protections for whistleblowers, and I think it's great, and Grassley's put that in there. I just find in general, yes, you do get some whistleblowers, and you talk to them and say, now, is anyone going to know about this? They say, oh, no, they'll never figure it out it was me, well, this issue. I say, well, it is true, I've written 22 emails to the company-wide on this, and I was at the shareholders meeting raising this, but yeah, no, they'll never figure out it's me. I'm like, well, okay, this is going to work out great. But I think that provision, and then also provision kind of along the same lines that you're talking about, Lee, on better communications, allowing the IRS at certain points to be able to communicate that, yes, the issue's been taken up in exam, yes, there's been proceeds. I don't think there needs to be a host of communications. Whistleblowers, will always like more, but I think the reality for them to keep the home fires is kind of more limited.
So this
points.
is key. This is what Dean's saying now, and I think Dean may have been a little involved in getting this done, but the thing is that there's a law's been passed that now is going to...
Out of the Finance Committee.
Out of Finance, yeah. We're waiting for it to be signed, okay? So, but the thing is that if it does, that there could be at least 2 or 3 more touch points during the process. And that's all, I think that's all that the program really needs to really heat it up, is those 2 or 3 more touch points. When you know that this is happening, now here's where your claim is, now's here your claim is. And the whistleblower office has been unable to provide that information. It's not that they don't want to do it, they can't do it, because it could be deemed a violation of 6103, because now if you tell a whistleblower, yes, the claim is in the field being audited, you've just confirmed that that taxpayer is being audited. And that's taxpayer confidential information. And so you do need a legislative fix there. And so the key is it a fix that takes into account the 6103 concern?
Yes, sir.
Yeah, so if that's been thought through, then that's fabulous. If that goes through, I think that's going to give the whistleblower office a lot of steam, because it is a long process, 5 to 8 years. I'm seeing more like, 7 to 8. But during that period, if you know that there are 3 touch points, and this is what you should be expecting for a good claim, and if you're not hearing back in those touch points, something's happening, then you're waiting for a rejection. But there's just more of a feel. And the practitioners like Dean and I, we can fill in the space around those touch points for the clients.
I think well said. I was going to talk a little bit about what's a good claim and a bad claim, Brian, but I didn't want to know if there was some points you wanted to
I'll tell you what, why don't I make a couple, I'll take 5 minutes and make a couple of overview points, kick it back to you for a good claim and bad claim, and then we can hear some more about what Leah's got to say about what we've been talking about. But I wanted to give you some of my perspective from where I'm coming from, which is a little bit unique, because I represent a lot of taxpayers who are non-compliant and who want to get compliant through what we call the Voluntary Disclosure Program. You all know about that. Interestingly, there's a domestic voluntary disclosure program, as well as the international one that's so well known. If somebody hasn't paid tax on some rent from a building down the street, you can disclose that and avoid criminal prosecution, as long as you fulfill all the requirements and you're completely accurate and truthful, et cetera. So I do a lot of voluntary disclosures. I've brought over 2,000 people in with foreign accounts. But then in addition, I do a lot of the whistleblower work, and so that's what we're talking about here. And then I represent a lot of the taxpayers, again, against whom the whistle's been blown. So I see it from all different perspectives. And when I talk about voluntary disclosures, by the way, this is maybe interesting to some people. We also work with some professionals, some foreign bankers, foreign money managers, who were helping people do things. And there is a way, there's not a program, but there's a way for those people to come forward so that they can either avoid prosecution or enter into perhaps a non-prosecution agreement and pay a fine, a deferred prosecution agreement, or look, some cases the facts are just so bad that the government's not going to give them a pass. But maybe coming forward would still be in their interest, for example, if they want to travel outside of their home country without the fear of being indicted or picked up by Interpol. So all of that can be worked out with the IRS, and it's important to know in the context of the whistleblower program that there is an escape valve or a release valve. Another overall point I want to make is when we're talking offshore, because we're at an offshore conference this morning, we're not talking just about offshore assets. Other ripe areas for whistleblowers are foreign companies doing business in the United States. They're liable for tax. Section 882 of the Internal Revenue Code says, if you're completely offshore but you're touching the U.S. with your business, you got to pay tax in the U.S. Just like somebody's got U.S. source income, or maybe there's a non-citizen who spent too much time here and they're a resident, should be paying tax in the United States. That's one area. Another area that the IRS is really focusing on now is payments to foreigners can be subject to withholding. So you make a payment, a U.S. person makes a payment to a foreign person subject to withholding under Section 1441. Not a lot of compliance in that area. It's getting better, but there's a lot of non-compliance, which is something people should be looking out for. And then, of course, there's the traditional transfer pricing, where companies are transferring profits away from the United States under 482. That can be allocated back. So those are areas that people in the offshore world should be looking around to see whether there's compliance, whether it should be corrected through some form of voluntary disclosure or approach to the IRS, or if that's not going to happen, maybe a whistleblower claim is appropriate. So those are just some overall conceptual things to think about. And I'll kick it back to you to talk about what's working,
Right.
Dean, and what's not.
Well, we'll talk about, it's kind of going off of Lee, but maybe a little bit of a sharper pencil on it. So, look, we get a lot of folks coming, as Brian and I both have a lot of folks coming to us, and that's fine. But I would say, number one, I want to hear about timing. When your story starts, well, in 2002,
No.
no. Obviously, if they haven't filed and they've not been compliant and they've never filed, that's a different story. I'm interested in that. But, in general, if your claim is going to be, well, it's fraud or it's this, it's very difficult for the service to deal with. I'm much more thrilled when I hear it's current,
ongoing.
Current and ongoing.
Yeah,
They're still doing it.
The service does not want to prove a fraud case in order to make your whistleblower claim. Remember, they've got overworked, underpaid, they've got a full inventory of current stuff You know, don't come to us with a 2007 or 2009, or at this point even a 2011 case is starting to get a little hair on it. So.
But offshore is the one difference on that, because happily you need to file, and if the years are always open, so
then it's a current issue.
It's a current issue. So yeah, praise the Lord. So you've got that. I like insiders a lot. I like people that have good information, good knowledge, and good documents, if possible. I mean, you may not get all of it, because you got to think about, we're having to convince the service. Again, they're hardworking, they're overworked, they're other stuff. They've got to make a commitment to this case. They've got to, it's not just, and they've got to look at it and say, well, all right, who is it that's telling us this? Far better to say, well, yes, this is the bank man, this is the person, as opposed to, I think what he's kindly saying is, as opposed to, well, I was looking at the SEC filings of, the cotton industry, and, it looks like those
I think
boys
it's rife with fraud, yeah.
Yeah, I think there's a lot of fraud there. Yeah. And I think, go ahead, did you?
Yeah, no, you got to have documents, okay? That's going to make a much stronger case. But, a lot of caveats around that. Don't go stealing documents, because you have to have usable documents the IRS can actually use. Documents are helpful. You're going to want identities of people. You're going to want, charts. You're going to want to show specifics about amounts if you can, and really tie it to particular years. So the more particulars, the more facts.
Right, and the specifics, it goes back to Lee's point, specifically who did this. And then I think part of it too is when it's part of a bigger thing, in other words, hey, it's not just this one person that's doing this, say 1031 shenanigan. This is wildfire. This is going on, 30, 40 other people are doing the same thing. But then it goes to that point of, and it really, quite frankly, is good pleading for you. I don't want to bore you with all the details, but you want to name all the actors, all the participants, their names, addresses, because you're going to get credit for all that, as opposed to down the road, if you haven't given those names over and the IRS had to find them themselves, then your lawyers are going to have to struggle to say, well, we helped make that happen, kind of a deal.
And the key is, if you want it to catch fire, you got to make the IRS's job easy.
Yeah.
You got to do the work for them. That's the only, not the only way. It's the best way to get your claim to catch somebody's attention.
Yeah, and it's going to help you on the percentages. I mean, the easy way to think of it on percentages is the more, and it's a fair way to think of it, is the more work the IRS has to do on a case, the lower your percentage is going to be. The more it's on a silver platter, the better. I mean, the way I think of it, like on offshore, those out there, if you've got an offshore issue, well, I'll tell you, I want name, address. Why? Because there's a lot of John Smiths out there, and this is a problem that comes in. You think, oh, well, I got the names. Well, okay, in the United States, guess what? There's, more of these folks than you think. Name, address, the account number, the account balance, and any documents that support that. Get that on a nice little stick drive. Life will get moving for you. But that's the kind of details on it. You mentioned having an attorney. It's obviously for two attorneys here to say, yay, go team. But I would say it helps a lot. I think to your point, Brian, of that, I think the challenge of a good filing is really in 8-10 pages trying to condense everything that the client knows in a readable format that at your beginning level, someone can pick it up and say, I get it.
Right, and so what we got and what we don't want is the 80-page just sort of narrative that goes on and
Single-spaced.
on. And then you can find somewhere around page 47 the 2 lines of relevant information. That's not good. You want the 8 to 10 page bullet points, maybe some exhibits with tabs.
Right, yeah, no, definitely
Keep it short and sweet.
I think that's right. And then, we provide a legal analysis, even though, of course, it's the IRS and they understand it, but we think it's sometimes useful to say, well, look, here's how we see it, here's what we think it is. And then I think two of the challenges, kind of your point is, even putting it together a draft IDR, but I think the biggest challenge, because of this difficulty of the communication, is when I'm working with whistleblowers, getting them to anticipate the potential defenses coming back, not only from the IRS, but from the taxpayer themselves.
Because sometimes they're so darn obvious, right? The whistleblower says, they didn't include it on the estate tax return. They didn't include it on the estate tax return. And, sometimes you have to look at them and say, yeah, but the only beneficiary of the estate was the spouse, so there's no estate tax, and I've had that case, it's $10 million. I know they didn't file, and said, yeah, but everything passed to the spouse, so there's no tax. I mean, and so those types of things, you really got to understand the defenses, because then, Lee's office is going to go through and understand the defenses, or maybe they'll send it out to the field, but then it just dies on the vine because, that dog isn't going to hunt.
Yeah, and I think, too, that you just kind of finishing up on this side, Brian, get obviously any of your thoughts. I think it, just like the service in general can have the devil with some cases. I mean, I like them when they're just right over the pot, but like take a 482 case, well, they get it, the service gets it. They're very, very difficult, and it's, if it's a valuation case, it's a conservation easement case. I'm going to want to have a lot more
Yeah.
there than just, well, don't feel right to me, you know,
Well,
because.
it's going to take a huge allocation of IRS resources. IRS does not have extra resources to allocate to your whistleblower claim. You've got to make it interesting to them. You've got to make it compelling. It's got to involve real money, you know, and the more detail you give. So if you're going to come and say, hey, I know this company's engaging in transfer pricing, I just know it. Look, their profit's gone down the last 3 years. That's nothing. You know, that's not going to do it, because a transfer pricing case is a huge lift for the IRS. So they're going to allocate their resources to the most promising sources of information.
One last thing I wanted to touch on, Dan, turn it to you in the audience for questions, and Lee, obviously, if there's anything you want to comment on, is tax court. Because Brian and I both, and you know, I don't mean to sound like we're polishing the silver here, but really been kind of the most successful folks in there. I've won a number of cases and got folks paid. Brian's had very good success in tax court. And we were talking about this again. You're really seeing a huge upswing of people who want to go to tax court, because Lee's shop has been so good at saying, you know, love the shoes, love the hair, love the dress, but yeah, no. A lot of people are getting no letters as they're cleaning out the stables, which is good, because I think it'll give kind of clarity for it. But a lot of people are then saying, well, hey, I want to go to tax court, looking at some of the cases that we've had success in and saying, oh, well, that's me, that's my case, I should get paid too. I would tell you, if you're getting a no letter, you know, there could be a real reason for a no letter. Is the IRS perfect? No. Are there some disagreements about the law, about what we think should get paid versus where the service will? Yes, and I mean, we've had success in that, but here's what I would say to you at a core, and it actually comes from a statement the judge made in Brian's case, Whistleblower 1, Whistleblower 2, one of the few cases with a useful name, I might add. The rest of them have these terrible names of, my cases are all like Whistleblower 38769, like, it rolls off the tongue, terrific. But three things I want to see. One, did you provide information? I know it sounds obvious, but two, did the IRS take action? And then three, was there collected proceeds? If you've got those three elements and you know you've got those three elements,
Then maybe you have a good claim. But if you've got no sense that there's collected proceeds, I don't know that I'm just going to run into tax court unless I really think I'm missing something. Because here's what happens when you got to go to tax court. The burden shifts in terms of the allocation of resources and the burden for, when you make your whistleblower claim, you put it all together. Dean and I do our job. We try to keep a nice presentation. You send it in. Now the IRS has to do all the work. When it goes, if it's been denied and you're going to go to tax court, now the whistleblower's back in the hot seat and their representative. It's a lot of work to get through tax court and get to some information that's going to give you the information that you, whether it's a good claim or a bad claim. So really got to think about whether it's a decent case. And here's one sort of area that really does need some help. The tax court is not made for whistleblower cases. The tax court is made to hear cases about a taxpayer's own liability where you've got two parties, the commissioner and the taxpayer. And there's not a lot of discovery in tax court. Why? Because the taxpayer knows what their tax situation is, and presumably the commissioner has a pretty good sense because they've already been through a whole audit on this issue. So there's been a lot of exchange of information in an ideal case. You get to tax court, one of the parties knows everything, and you can have some more discovery, and then you go. So in a whistleblower case, completely different. Right. You've got the commissioner, a whistleblower, and the taxpayer who's a third party, not even a party to the case. The third party has all the information. Can you take depositions of the taxpayer? Can you get document requests of the taxpayer to find out what happened during their audit? Not really, and the IRS may not have all the information about what happened during the audit, believe it or not. They've got what they've got, but they don't have the taxpayer side of it about certain things that happened. So, you know, it's not a complete story, so the tax court rules need to change a little bit and catch up with us.
Right. I would say this, and I know you've had success, and I have too, is that I think the tax court, again, being pro-whistleblower, if they feel there's something there, they're pretty good at it.
Well, that's what's happening now. We're seeing that finally, if they think there's something there, they're going to do what they need to do to dig down and provide the information and get it adjudicated.
Yeah, they're not going to just take the IRS's say-so and say, oh, well, they told us it was okay. They've made that clear. Yeah, no,
But to your point, Dean, there are a lot of not worthy cases out there. So you're seeing, 50 cases that have just been rejected on a motion for summary judgment. And maybe 10 that are still alive after the motion for summary judgment. So, the overwhelming majority of tax court cases just get kicked out.
Right, but those are the hallmarks. I think that kind of covers pretty much what we want to. I want to go ahead, Lee. You bet. Yes, sir.
Here you go. Use this one. Perfect.
So I'd like to make a couple of comments in regards to a few of the items that were discussed. Deal with these kind of in the reverse order. So, and I think you guys highlighted or talked specifically about the litigation. And the increase. So from my office's perspective, the more I work what was classified as backlog and clear through and review the older cases. Obviously, there are going to be more cases that go to litigation, and we're doing that. Again, we're working as much and as fast as we possibly can. So from a office perspective, my number of cases in litigation are definitely increasing. One other thing I talked about is, and I mentioned, I want to clarify this, that the number of claims that are being rejected. So I stated before that whistleblowers who go to attorneys obviously helps with the screening, because hopefully the attorneys are telling them, in their opinion, kind of what they believe will make a good claim, just as what you heard. However,
We don't want to waste our time either.
however, again, that does not stop necessarily the claim from coming in. I mean, they can still file individually from that standpoint. So, so again, it's not the end all.
You know, Lee, and I think that's a good point, and I think one of the reasons, I think that things are a lot of positives out there, but by getting rid of the backlog, you're right. In some sense, you're getting folks coming forward because, say, the claim's been there for 5 years, and, you know, they don't think you just, you know, we're making paper airplanes, or they're convinced, well, it's sitting there for 5 years, by God, you know, they should have been doing things. And the truth is, and I think what's going to be better is, I think, you know, more quickly your shop saying yay or nay, or, you know, rejection, you know, within, say, a year or two, you know, I think people will be less likely to think, oh, I know they must have done something, and hopefully that'll, I think there's other things we can do to kind of make tax court try to, you know, we've talked about that, about maybe having conferences, you know, before tax court, or maybe even after filing, so that whistleblowers can kind of have the curtain pulled back a bit under protections for taxpayers' rights and information. But I think that factor where you won't have these, you know, 5-6 years sitting out there, then getting rejected, I think it's just natural for the whistleblower who's been, you know, hoping and dreaming all this time.
Yeah, there's this real suspicion on the part of a lot of whistleblowers that the IRS really did collect money. Now they just don't want to pay. They're not going to pay. They got the money, now they're not going to pay. And, you know, I know that's not what's happening. You know,
I will
so
reiterate that I am here to pay awards. Take that with you. No matter what you take and leave it, I am here to pay awards. Speaking of just what you said, Brian, on that, so I, as you can well imagine, I get a number of calls after people receive denial letters or rejects, say, what can happen, or what can we do, or let's talk about this. And obviously there's a 30-day period for some under the B claims, or there again, or if you have additional information, please, you know, please resubmit that. So, and sometimes it's, what's ironic is that when we say, if there's additional information you want to add, or if you have something that you want to say, resubmit. So I will then in turn get the same referral, but now just in bold letters.
Pink stationery, pink letter, yeah, sure. Yeah.
So,
All caps.
all caps.
All caps.
All caps. So.
Right, let me say that harder. We both get a lot of folks who get the rejection letter, and they got tears in their eyes, and they want us to redo their earlier shoebox submittal. It's nice that you offer that. I would say, because there is the timing issue, maybe it'd be better if there's quicker rejections, but, you know, often it'll be someone that's been rejected 3-4 years down the line. The timing issue has already kicked in, and it's hard to resurrect. I just don't even really do it that much. I don't know about you, of, you know, yes, let me see if I can, maybe if it was right out of the box. But the key thing I would tell folks, I'm always shocked when I thought you were going to go with it, Lee, is they'll say, well, you know, I was waiting for them to call me because I've got the killer email, you know, from Jane to Jim saying, hey, this is illegal, can we still do it? You know, but I was waiting for them to call me, and I'm like, dude, you got to put your best party dress on to the IRS. You cannot step back and wait and say, well, I'm going to tell them the key fact when they talk to me.
That's a killer mistake. They're doing that.
And so, again, the point is not that resubmitting the same information is not the answer there from that standpoint. The other is in regards to help from the whistleblower. Obviously, we are our intent is to debrief, and if not, we will generally have a valid reason for not doing a debrief. So that's where we will seek initial assistance, and we're also looking for the right candidates to do the 6103 in contracts, whereas from an upfront perspective, we can have that back and forth to help with some of the information that is being submitted. So those are all opportunities that We continue to hear from GAO and others, as well as the industry that we continue to explore. So.
And I think that's just so helpful because I've been in meetings where, we've had a good give and take and we've, it's not been a contract obviously, but you could just tell the kind of the light went on because the service understandably is like, well, this is all, for the birds. And it's very critical when you're in these meetings to kind of try to listen closely. Well, what is their concern or what is their issue? We finally got out of one person, well, look, they're just going to take rid of the, risk by setting up this contract over here. And the client, the whistleblower came right back and said, oh yeah, no, they did X and Y to make sure that didn't happen. I mean, they knew that already, but it's again that it's so difficult for the whistleblower to anticipate every potential defense or permutation or thinking on the other side. And that's where it's so helpful to have, not even in having kind of that more of a give and take at the working level of the service as opposed to even just the kind of the initial run. But Dan, we've kind of been jawing. You got thoughts or get the audience?
Well, I want to make sure we leave some time here for questions because I know everybody has, or I hope you have some. A couple of things I just want to say real quick because I think I'm in somewhat of a unique perspective because I worked both sides of this. When I was with the IRS, I worked whistleblower claims, almost all in the offshore arena, and I worked a lot of them. And since leaving, I've been working with various law firms, helping them develop good whistleblower claims. And I want to basically reinforce what Brian and Dean said. I am not an attorney, so I'm not campaigning for business here. But when I was in IRS and since I've been out, there's no question that when there's a lawyer involved, the claim is better. It's better because they understand the laws, they understand what can be done, what makes for a good case, what doesn't. I've been, if you're going into the hospital for surgery, you don't want a general practitioner working on you. You want somebody who knows how to perform surgery. And I've been amazed by some of the attorneys who are, when the whistleblower law came out, a lot of the attorneys saw this as a money-making opportunity. This is going to be quick and easy money, and then I can go on and represent my other clients. And a lot of times they made some of those key mistakes, which is that they withheld documents. I had one attorney one time say, provide me with a write-up that he was going to submit and say, could you look at this and give me your opinion? And I looked at it, and I said, well, you mentioned certain things. Is there any evidence related to this? And his answer quite literally was yes, but we're holding that back in case they reject it. We want to come in and provide that at a second go-around. And it was like, that's the absolute wrong thing to do. You want to give the IRS absolutely as much information as you can up front. I've had attorneys say to me, well, we don't think we should have to do the work of the IRS. Well, then you aren't going to get an award. It's not a point of doing the work for the IRS. The IRS is very capable. I assure you, they can do the work very easily. But if you can provide them with good quality information up front that takes them where they need to go quickly, it speeds up the award process, it speeds up the investigation, it makes for a better case. It's a win-win for everybody. Holding back information, holding back critical information, not wanting to develop a quality referral because the IRS, hey, they should be doing it, well, then you're not going to get an award. It's that simple. So anyway, so I just wanted to say that. I did want to raise one question because I am a civil guy in many ways. But I'm certainly was on the civil side of the IRS. Offshore has gotten the high profile. I mean, that's what everybody talks about, and we're in an offshore conference. And the offshore people are very, very good at working whistleblower cases, as you said, Dean. Yeah. I'm going to tell you they're very, very good at it. As far as I'm concerned, they're among the best. And I agree with your comments about that the whistleblower program doesn't just relate to offshore; it relates to a lot of stuff. And in the large case arena, when you're talking about the multinational corporations, there is a certain kind of culture that exists there, and there is a certain kind of belief about how things ought to be done. But when a case goes criminal, certain other things kick in. And when a case goes criminal, you're dealing with statutes of limitation. Particularly on the civil side, you're dealing with statutes of limitations. And while criminal investigations are going on, those statutes are running. Now, when I started in the offshore game, there was a 3-year statute for offshore. And we were able, through campaigning of Congress, to get that extended to a 6-year period. And now there's a 6-year period if there's any portion of it relates to offshore. Criminal investigations take a long time. They are normally conducted through a grand jury. grand jury information can't be shared with the civil side. So I personally experienced situations where a case got handed to me after the grand jury had completed its work, and I now either didn't have a statute or the statute had, you talk about not getting a case, 2 weeks before, I didn't want to get a case 2 weeks before either, Any thoughts on that? Any suggestions? Any ideas on?
The whistleblower always thinks, well, they'll just run right out and get an extension. There's still a week on the statute. They can get an extension. And, it doesn't work that way, of course. The IRS isn't going to run out and get an extension just so they can evaluate your whistleblower claim. But yes, I think the point you're making is if the case, you're going to take it to CI, and if it's a criminal case, then you better hope they make the criminal case. And because if they make the criminal case, then restitution of taxes is going to come at the end of the criminal case, but it'll be there. Now, the downside of that is a lot of criminal tax defendants don't have a lot of money after the end of the process. They pay the lawyers. But meanwhile, during the 6-year investigation, their business is tanked. Maybe their marriage is broken up. There are a lot of costs around that. It's a very difficult time for them. So a lot of taxpayers get to the end of the process, don't have a lot of money to pay the tax. But in the end, there will be an order to pay the tax in most cases. Whether they can pay it's another thing. But what you're talking about is if the IRS does not make a case, or the grand jury does not make a case, then the whole thing has been screwed up because, yeah, you're right. You have the 4 or 5 year investigation. Statute's been ticking. At the end of the time, there's no time to make the civil case. And so that's the danger.
So there's somewhat of a risk in
No matter when.
Yeah, and I would say, Dan, probably maybe to be clear, when I think of criminal, I guess I'm kind of thinking of, and I'm happy to go regular order or happy to go wherever, but let's say I have a Fortune 50 company or a major bank, and let's say it's not dealing with offshore. We were, again, talking about this. I am fearful of doing criminal because, and I don't mean this to sound hard, but good luck anyone in the government really bringing a criminal charge against, Bank X. Yes, I know there's examples, but it's much more that scenario. But it's more, yes, let's talk to LBI, but let's talk to U.S. Attorney, Southern District, and see what they think about this bank. You get the idea. Mm-hmm. It's kind of maybe bringing. It's all part of the challenge for us as attorneys. And you're right. You're talking. I was thinking about it, Brian, when you're saying what kind of the types of attorneys is. To do this work, you not only need to know tax law, you need to know this whistleblower law, you need to know the IRS. I mean, we spend a lot of time trying to, get it to the right person or be thinking of the right person and packaging it there. But you're right. So I think you raise a fair point of if I had a Fortune 50 company, even if I thought it was, quote, criminal or the client did, sounds.
I agree.
Yeah.
Well, because in a criminal prosecution, the government is not primarily looking for the money; they're looking for the prosecution.
Exactly.
And then the money that they're looking for may be more in the area of criminal fines, not necessarily tax payments. I mean, I would think tax payments probably comes third. They want the prosecution first, they want the criminal fines second, and then they want the taxes paid.
Yeah.
Okay, and just one real quickie, and then we'll go to the audience, which is, you have a legislative background. Do you think there would be any receptiveness at all towards statute extensions of an automatic nature when there is a whistleblower claim?
I think the concern would be that it would then signal that there's a whistleblower involved, and I think that's where the concern would be. In other words, okay, the flare just hit, we're going to extend this, and we're using our special whistleblower provision to extend it. Then they'd say, I bet there's a whistleblower involved with it. That would be maybe the
I think that's one. Also, I don't know that it's fair to take a taxpayer against whom the whistle's been blown and say you have a longer statute than a taxpayer who hasn't had the whistle blown. There's some equity there. I think the fix around that may be appropriate is some sort of prioritization of whistleblower claims and whistleblower information. Now, you can't make whistleblower claims, the #1 priority, because then that denigrates the normal audit plans that the IRS has in place for very legitimate strategic reasons. They audit certain ways and in certain taxpayers, and there are reasons for that. So you don't want to say those go to the bottom of the list, whistleblowers go to the top. But I do think we need something that says whistleblower claims get equal priority with other things and don't automatically fall to the bottom, which I think is a cultural thing that is happening now, and it's beyond the whistleblower office ability to fix, I think.
I would say, there again, with all respect on that, they do receive equal priority. I know that there may be a perception issue, but again, the claims, and that's the beauty behind that from that standpoint, is that they don't fall to the bottom of the barrel. Now, I know hopefully eventually as time goes and they're worked in a faster perspective, and there's more information that's shared, then that will come.
Well, the good.
come more to light from that standpoint.
Good
Good
point.
news.
Hey, Dan, I would say one thing I do on it, and Brian, I'm sure, has probably got his way to do it too. If I think there's a statute blowing, yeah, I mean, 1 week, I'm like, you're killing me. But, I mean, for us, really, a statute blowing is like 3 months, or it's an audit, they're closing. A classic one would be they're closing out. They're going to be closing out this cycle, and it's not too great, quite frankly, Dan. But is to try to ring a bell. I mean, try to, and I'll send a cover letter to the lease shop and say, hey, alert, very big bold face on pink paper in all caps, hey, this is a statute, driven issue. So at least we've got a fighting chance, and try to get it, make sure that someone there understands that, this we think is time sensitive. So does it work all the time? No, but that's what I found the best bill is to kind of ring the bell.
And just because this is an offshore conference, and I don't know how many of you know U.S. tax law when it comes to offshore, but there are certain things that automatically keep that statute open. I wanted to raise the issue for discussion purposes, but I mean, a lot of you may not know that U.S. taxpayers who have offshore IBCs have to file forms called 5471s, and if they have offshore or foreign trusts, they have to file 3520s. These are forms that if they don't file, they keep the statute of limitations open practically forever.
Definitely.
For those items. So it's not as big an issue with offshore. If there's an offshore whistleblower coming in who has information, that's not going to be the same kind of thing. But when you start looking at the entire program across the entire Internal Revenue Law, then it can become an issue. And with that, I'm going to go up here to take questions because what you don't know is that we have blinding lights in our eyes. And if you raise your hand, I won't see you anyway. So I'm going to go up here, and if there's somebody that's going to walk around with microphones and stuff like that, so I would ask if there is that you speak into the microphone, and the reason for that is because this is all being recorded, and that way, a lot of people say, I don't need a microphone, I have a loud voice. Yeah, but it won't be on the video.
There's a question up here, I know that. That I can see. I can see the front row.
Is there a microphone? We can get this down to you quickly.
Is somebody bringing a microphone around or not? Okay, well then I guess you got to yell.
Here we go.
Thank you, moderator. And thank you also to the panel for a very informative presentation. My name is Cordita Babshafer, and I'm from Barbados, but I'm speaking in my personal capacity. It appears that the IRS is taking a very aggressive stance in relation to offshore jurisdictions. But my understanding, based on the discussion yesterday, is that no similar stance is being taken in relation to states like Delaware, Nevada, and Wyoming. Is this correct? If it is correct, why is this the case? If it is not correct, why not? Thank you.
Right. So the issue of kind of the U.S. and its taxes and openness are certainly something that we're aware of in our country, and it's a kind of a point of ongoing discussion. I would say, though, that that and a hanky will get you a hanky in terms of U.S. efforts offshore. It's just life isn't fair, and it's not perfect either. But I think there is an awareness of that, and I think it's been kind of brought out. And I think looking at the OECD efforts in this area as well too. So I don't mean to sound dismissive. I think it's a fair point you're raising, and I think that's being recognized by folks. It's a little difficult in the U.S. too because of the federal structure of, well, this state does it this way and kind of what the feds can do. But I think it's something that people continue to think about and talk about what they can do and what have you. Go ahead, Brian.
Oh, just in the context of whistleblowers, which is what this panel is if we know that somebody's using Nevada, Delaware to evade U.S. tax, that's definitely a great whistleblower case. We would bring it. And then also, if the other countries, as Dean pointed out, had their own whistleblower laws, then whistleblowers could be, bringing cases to Barbados or to other countries. So in the context of whistleblowing, I don't think there's any real issue or distinction there. We just need to find who we take the claim to. And if it's U.S. taxes, we take it to Lee.
Yeah.
I think
That's a good
also
way of
just,
thinking.
I want to add something to that, which is that many people, me included, agree that Delaware, Nevada, Montana, that those are problems. And Senator Carl Levin proposed legislation many times to address that, and there's legislation before the Congress right now to address that. So your point is well taken, and your point is being addressed, or at least attempts are being made to address it. Having said that, as Brian said, from a whistleblower standpoint, as someone who was inside and now outside, I can guarantee you that if there is a whistleblower out there that has information related to violations of IRS laws that are going through Delaware, Nevada, or Wyoming corporations, they would love to have the information and they will pursue it if it's a good
Right.
case.
But just one last thought, and I know we'll get to other questions here. And I don't mean this to sound hard, really more hopeful, is that I've had 2 cases I can think of that we brought in that are banks, and they're banks that are not kind of U.S. banks. They're banks that are really set up in the U.S. for foreigners to come in and do it. And now we've had a whistleblower come forward because of them violating U.S. tax laws, and we made those files. Well, the whistleblower had 10,000 names of people with illegal accounts from all over the world, including the Caribbean and Latin America. There's no hay in the sunshine for that. There's no award program. Imagine if the Caribbean all had an award program. Imagine if Latin America had an award program. Hot dog, the whistleblower would be thrilled to have provided that information. But right now, all it does is expose them to potential, retribution, attack, things like that out there. So, one thing to think about is just, what can we do to be encouraging whistleblowers coming forward from the U.S. is a thought. But, Dan, I'm sorry.
No, please. Any other questions? Anybody else? Over here. Where's over here? Well, I don't know where here is. I can't see you.
It's
But
the back, way back.
Thank you.
Brian, this is going to be like a new gig for you.
Yeah, I know. I like this part.
You really do.
Talk show.
Thanks. The question I want to raise is about the informant who is in a country where turning over the data is a crime. And now they're in the situation of being potentially prosecuted wherever they got the data. The data shows amazing violations of criminal law in many jurisdictions. And there's really no protection for that person against extradition and against red notices with Interpol. What do we do to protect that kind of informant?
Okay, so I guess the question is if somebody's here in the United States and has information about noncompliance in a foreign
We're
country.
talking about a foreigner.
A foreigner, but.
Outside of the U.S.
So they're outside the U.S., so they're not going to be, so what should the U.S. do about
Well,
protecting?
if they come into the U.S., will the U.S. arrest them and turn them back over to the
Because they
country
violated
that seeks-
another country's
That's
bank
right,
secrecy laws?
exactly.
No, I don't think the United States is going to enforce
Well-
another country's bank secrecy laws.
It turns out that the State Department would not answer a letter to say definitively they wouldn't extradite someone from the U.S. because of violation of a foreign bank secrecy.
And I understand that. They're probably not going to give advisory opinion about what they may or may not do in a
Okay.
particular case. So, yeah, you won't get that kind of comfort. What you should do in a case like that is talk to an attorney who understands sort of how the IRS and the government is going to treat that sort of thing. And it depends on the facts of each case, but I think it's unlikely, in most cases, the United States is not going to assist another country in enforcing its secrecy laws, especially if those secrecy laws are preventing somebody from giving information about a violation of U.S. law. But, that's just a general comment.
Yeah, I've had that situation, and I think it's, you're not going to, to kind of just go in and say, can I get an official? That's just not going to get you there. They're never going to get a comfort level in that regard. But the way Brian particularly teed it up, I think you should be able to find a happy place, at least in the U.S., for that person, right? If they're bringing value to the United States government, I find that they're very responsive to trying to protect that individual. So,
I don't know what would be done. It's an interesting hypothesis, but the notion that somebody would file a whistleblower claim with the IRS from a foreign country, be charged in the foreign country, have an Interpol notice put out to have them arrested, have them come to the United States, and then have the United States arrest them and return them to the secrecy country would be like something that they...
Right. Yeah, I mean, what we've had is more the other side, which is we've had people in foreign countries who are violating their laws to provide information to the IRS, and the concern is about them being arrested in their country. And that's where I think the IRS has been terrific at protecting that individual's identity, their information, all that has been extremely, extremely good at doing that. we've never, well, we've had an occasion or two where we said, can this person end her? And I think they've been open to those discussions to say, yes, we can look at bringing them in, so.
Anyone else? Anything more? Going once? Twice? All right, I don't know if it's time for a break or not, but we are done, ladies and gentlemen. Please join me in thanking the panel.
Hey, that was great. Hey, Lee,